Yes, the question was whether or not, or currently, school boards through an East Blast argue that they're not allowed to use any of that money for road, other infrastructure, traffic safety devices outside the school. When the county addresses them and suggested it, they say, perhaps we would like to, but our hands are tied because state law prohibits it. Jim, I mean, that's basically prohibited in state law. Melvin, I can tell you that about 3 years ago, 4 years ago, we tried legislation or getting legislation through. We actually had a bill sponsored that would have opened it up, that would have untied schools' hands so that they could actually use that money for infrastructure improvements. They were against the proposal, and it did not succeed. We will continue to look at that. I mean, in the near future, there may be changes to the East Blast laws, and if is there a large bill or something going through, we will certainly speak with the author to leadership to try to allow that money to be used for transportation or road improvements, safety improvements for the children at the General Assembly. But we've tried, it's been unsuccessful, and currently it remains prohibited for them to use the East Blast money for those purposes.
Just encourage you to continue to do that. I think that's something that's really important that affects all of us in each particular time.
Certainly, and again, every time a lot of these issues in the platform we haven't been able to address. We've tried over the years, but you've got to wait for the exact right time. And next time that the schools have Clint Mueller. At the right time, if there's a bigger bill or if someone needs a compromise or wants to work with us on something else, that's when we pull these out, and we're fully aware of that position, and we'll advocate for it next time there's an opportunity at the General Assembly. Clint Mueller, ACCG.
Actually, Sean, you had some discussions this legislative session, I know with the DOT and others on this topic, and I thought there was a piece of legislation where we were going to require some notification at least. Can you tell the group what happened with that?
There was. House Bill 802 is actually sponsored by Henry County's Andy Welch, and it was an attempt to take the East Blast was a constitutional amendment, the resolution that accompanied it was 1109, and the attempt there was to open up East Blast to operations and maintenance basically in certain curriculum. And as a part of that conversation, since it was that opportunity, as Todd spoke to open up the Constitution with regard to East Blast, we went to the sponsor and actually had an amendment presented in the House Education Committee, because that's where the bill went through, to try to require school boards to at least have a meet and confer on the front end. So anytime that they look to do an infrastructure project with East Blast that requires transportation improvement, that they basically reach out to the county on the front end, at the very least, let us know what those requirements will be. The county wouldn't have had any authority to prevent them from doing it or to stall the project, but we'd at least been notified up front so that the county could have better handled their budget, with having more notice or maybe even use LMIG funds, things of that nature. I know it's something that GDOT's looked at kind of behind the scenes in the past, tried to talk to the state DOE as well, but that particular amendment, when it was brought forth to the committee, with some conversation and concern from the School Board Association and others, of course, they were opposed to it. The bill sponsor backed off of supporting the amendment, which meant it required a motion and a second in order to get it passed in committee, and with him backing off during that committee process of sponsoring the amendment, nobody desired to bring the motion, so it failed for a lack of a motion. But I can say there were some members in the House Education Committee that understood the importance of that conversation, would like to see about having it continue in the future, but we do have that uphill battle with the school boards on that.
Yeah, apparently they don't even want to meet and confer. It seems like that would be a no-brainer. Just all we're saying is sit down and let us know what's coming. We're not asking you to pay for anything, but let us know. And they apparently were opposed to even that. So you all need to maybe have some conversations back home with your school board, school superintendent, and find out what their association's resistance is, just to simply inform you all ahead of time what their infrastructure plans are, instead of springing it on you at the last minute when they're about to open school.
I don't have issues with that kind of conversation because that takes place in our particular county. But the issue is, who pays? And if that's not discussed well in advance, and that does impact the funds that my particular county has in order to support infrastructure throughout the county, not only to the new facilities, but throughout. We only have so many dollars we can put on transportation issues.
And their argument was they were happy to have the discussion, but they want to have a broader discussion. So they don't want the meet and confer to be limited to the East Block scenario, they brought development authorities and all that other stuff into the mix as well during the committee and saying, let's have a discussion about meet and confer in the broad context in terms of counties and school boards. So that was their primary argument as a part of it.
Might I suggest that as we have GMA here, that we ought to invite GSBA, Georgia School Boards Association, to also participate in some of our discussions, because there are so many instances around the state where this is an issue. Is it still the case that if it is an improvement that actually touches school property, that they can legally do that sort of improvement? No? Yeah, say it's a red light that's right on the edge of the property. Are they allowed to? Because I know in the past that was.
They tell us they're not legally allowed to do the red light.
That's an argument, and still free to make. I think you would think it would be pretty obvious that if the capital outlay is necessary to serve that facility, like a turn lane, traffic signal, or something that relates directly to it, it should be, it would be logical to think that should be fundable through those resources, but they still argue otherwise.
Well, again, I mean, our next item is also with regard to school issues, so I just think it might be something worth considering if we're not already having behind-the-scenes conversations, that maybe we should actively pursue having some open dialogue with the School Board Association as well.
I think if we start looking at some local dialogue on that, you can tie it into the East Block. Tied into that general budget is going to be difficult, but I think we can get it tied into the East Block. I feel real good about us being able to make some inroads in that area.
Anything else on this item? All right, the next item is school growth. Todd?
Along with the previous policy platform, I didn't have any recommendations on this particular issue. Are there any questions or suggested changes from the audience? And that was actually school growth, so I believe are we on development impact fees?
Yeah, the next one. Thank you. You just read the title for me. Appreciate that.
Development impact fees. We're all familiar with them. We're also familiar with what's happening in the economy of recent. I didn't have any recommendations, or we haven't had any opportunities with legislation in the past few years. The policy position asked for such, eliminating impediments for their use. County should be authorized to impose other exemption fees, that sort of thing. It's development. While it used to be a hot topic 7 or 8 years ago because of the current recession, I don't think there's an appetite to do anything that may be seen as limiting it. It's tough enough to have one of these bills pass the General Assembly as it is, but I would not recommend any changes or any major initiatives attempted at this point, targeting either developers or impact fees.
I got a recommendation on that. Leave it alone.
Yes, sir.
Any other comments? Moving right along, the next item is districting home rule.
We've tried, this is basically allowing commissioners to set up their own districts, similar to what cities do. We've tried several attempts in the past several years unsuccessfully to grant this authority to you. We will continue to try, but as of now, there's not much of an appetite at the General Assembly. They like to have that authority. I wouldn't suggest anything change with the platform. I'm just letting you know the realities of the reception or lack thereof at the General Assembly toward this proposal.
In most areas of the state, are they just rubber stamping what you propose and the legislative delegation? But a few areas they're changing. Okay, I think I know some of those areas. Now it's coming back to that there are 2 counties I'm familiar with, one close to us and one
My county, Fulton,
yeah.
yes.
The Fulton and then Richmond County, the legislative delegation had some problems with what the local board came up with.
I actually think that it happens quite frequently.
It may.
It does, it does.
Our delegation didn't want to, they just, y'all handle it and went on through.
I think it's a mixed bag, and you just cited several worthy examples making that case, Murray. Any comment, Madam
Any
Chair?
other comment? Well, I could make comments on that, but we're not here to discuss specifics.
That's right, home rule is a good idea.
Yes, yes. Any other comments? The next one is open meetings, open records.
As y'all are aware, 3 years ago, we went through a significant rewrite on open meetings, open records, and as a result, significantly revised our platform because there were several provisions that we were able to get in. Some we didn't like so much, but overall, we addressed a lot of this committee's recommendations in state law. There's a couple more provisions, 3 or 4, that we are suggesting changes. They're currently in here. I don't believe this needs to be changed. Again, it's whether or not there's an appetite at the General Assembly to open up that statute once again, but when they do, we will, of course, try to get the changes that are out in front of you. Our attorney, Jim Grubiak, was very instrumental in passing the law. Jim, any comments on open meetings, open records?
I guess the only one might be worth thinking about is the very last bullet point in there, that in terms of what's changed since the law was enacted. There was some federal law that is helpful to us that didn't exist when this statute was last revised. This is the issue where you get requests from out-of-state
Sure.
requesters for records, and they're data mining basically. They're not really interested in the information per se, but they want to sell it to somebody else. There was some constitutional questions about whether that could be limited in-state versus out-of-state. When the law was last visited, since that time, there's been a federal case that, U.S. Supreme Court case that does specifically allow for a state's open records laws to distinguish between in-state and out-of-state. So it may be worth thinking about it, because it is a problem in some areas. A lot of expense goes into responding to these requests, and it really doesn't do anything for your citizens. It doesn't for somebody else out there.
So under the old law, in summary, it was assumed and really never challenged that we could have a right to deny out-of-state requests for open records. The current law prohibits local governments from doing that. And our position here is that would allow the county's discretion on whether or not they should have to respond to out-of-state requests, not so much because it's an individual curious with open meetings, open records at the state level, but it's actually companies that are data mining for other purposes.
Yeah.
So again, the last,
The policy is adequate, but I just wanted to mention that it's
I'm just summarizing for those that may not be able to hear. So, are there any other questions or comments on open meetings, open records?
All right, thank you. Next item. This is publication of the annual financial statements, and this is a 1952 law that's currently in place, correct?
It is. It's antiquated. We need to get rid of it. We hadn't been able to do so yet, but we will continue trying. And it will continue to work in this internet data age on these old postings, these filings, these public notice requirements to try to get our systems or our requirements up to speed to save county taxpayer dollars.
Todd, I'd be happy, you know where I'm coming from, I'd be happy to work with someone on this too, and we need to get that defined on what a financial statement can be that thick, or it can be just a straight balance sheet on it. But we need to determine how much of that needs to be published. You do your balance sheet and your profit and loss statement or income and expense, how much in detail needs to be defined and things of that nature. That needs to be defined, because, and not just where you have to publish your whole financial statement, because that's about, mega pages when you start looking at one of those things. And honestly, most folks can't read it anyway. So, and I think if we could get that thing summarized, we could just have an abbreviated balance sheet and an abbreviated profit and loss statement, income and expense, it would be at the benefit of everybody.
Yes, sir.
Any other comments? All right, the next item actually had some changes. It is the county liability failure to wear seat belts.
This has been a long-standing platform issue or position of ACCG. Bottom line, counties, we build roads, oftentimes we're sued. The argument is neglect of a road or we failed to replace it, etc. When we're party to a lawsuit, we simply want to present the jury all the facts. And in this case, whether or not an individual's failure to wear a seatbelt contributed, or that negligence contributed to any additional injuries, and if so, then the award should be reduced as such. In the state of Georgia, and there's a lot of legal terminology and a lot of details behind it, but the bottom line is, before a jury or trial, we are not allowed to submit that evidence, and perhaps mitigating some of the damages paid out by the county. We want to be able to submit it. We want the jury to consider it, and if it did contribute, then we want the jury to be able to reduce the awards proportionally. However, when we've introduced this bill, and it's been 3 times over the past 5 years, we can get it through committee. However, the Georgia Trial Lawyers Association is very active, and I'm not sure why, quite frankly, but is very active and is very powerful down there and is able to kill it on the House floor. We worked with the Georgia Chamber of Commerce last year, had some momentum, got it out of House Judiciary, never could bring it up for a vote on the House floor because, quite simply, we didn't have the votes to get it passed. We keep trying real hard. It's not going anywhere until the Georgia Trial Lawyers Association changes their position, or we can somehow muster the votes to overcome that significant challenge in this regard. So I did want to give you all a background. That was House Bill 504.
Questions or comments? Y'all are quiet today. All right, the next item is the building inspections, public duty doctrine. Todd?
We just want a change in statute to ensure that our building inspectors are not held liable for damages to private parties resulting from improperly constructed buildings. We'd always had this as a law. Several years ago, there was a court case that opens us up to this liability. We would like to change that statute, but you may guess also on this position who would be opposed to that. I wouldn't suggest anything needs to change with the policy. I'm just letting you know our chances for success at the General Assembly.
The chances of success is what?
It's be rather difficult because the opposition, who would obviously benefit from having us liable and being able to sue us. I believe I mentioned that trade association's name earlier. Yes, sir.
Is it mandatory that we offer code enforcement for buildings?
It is not. I know of several. I'm not an expert here. If Jim or if anyone else wants to, I know of several that have, yes, sir.
Can you speak up, please?
Georgia adopts the law of the minimum standards throughout the county. So you are held responsible at that point of meeting the minimum law. So, it's up to the county to apply that. And there are a lot of counties in the state of Georgia that don't. They rely on architects and engineers to hold those things in place and apply those codes. But you are required to meet the minimum standards.
And the question, I guess, originally, I'm just going to restate them for our web audience, was whether or not counties are required to have local code and building enforcement personnel on staff. And the response from the audience was that not necessarily, but the minimal standards have to be met. And I do know some counties that have actually joined together for a joint building inspection office between them or among them.
There are some counties now, unless the law has changed on that since I retired, because of the population of that county, they are required to have their own building inspection, required by law to have their own building inspection. It seemed like that was above 100,000 feet.
And I'm not sure on that. If anyone else knows for sure, please comment.
Well, I believe you're also allowed to hire a private contractor to do that for you, are you not? I'm pretty sure you are, if you don't have them on staff. Any other comment, question? All right, the next item is with regard to utilities and properly installed lines.
This has been a long-standing position. I don't suggest any changes in the first one. If y'all want to look over it real quick, let me know if there's any suggestions or questions.
And as always, should any legislation come up with regard to any of these topics, Todd, you'll let us all know, correct?
You'll get your weekly legislative update
Absolutely.
each Friday during session. Inform you of the bills, action needed, stay on top of things at the Georgia General Assembly.
Comments, questions? Okay, next item is the location and control of utilities. Todd?
Yes, ma'am. I didn't have any or staff did not have any recommended changes on this position. However, we have, Cobb County is currently involved, with an issue, with Georgia Power, and we have Linda Brunt from the Cobb County Attorney's Office. I'm gonna ask her to come up and speak, brief the committee on some of the issues that they're facing, and also gauge from you whether or not you're having the same challenges and what steps we may want to take moving forward with counties. Could you come right around this way, please? I'm going to let her sit here for your viewing pleasure at home.
She's going to carefully come up. We are wired, so make sure there's no injuries as she makes her way to the front. Welcome.
Thank you. Good morning. Thank you for having me. I'll try and be brief and give you a general view of what we've encountered. Historically, when we have had road projects, we have worked with utilities and have tried to give them advance notice, particularly the electricity providers, so that they could move their poles in advance of the construction taking place on the road.